like to talk a little bit about copyrights. Copyrights will give inventors some protection, and it's important you know what a copyright will do for you and what a copyright won't do for you. A lot of people say, well, I can just copyright my invention. Well, you can't. You can't copyright how something works. You can copyright a particular image of your invention, but you can't protect the way it works with a copyright. So what are copyrights good for the average inventor? Well, for one thing, you can protect your website. Websites are becoming more and more important to inventors who want to have some sort of an internet presence for their invention. So you can copyright your website. How often do you copyright your website? Well, I urge inventors to copyright their website whenever they make a major change to it, because the new material is not going to be covered by an old copyright. Now, you don't need to go crazy on this and copyright it every time you make a one paragraph change, but certainly every time you make a major change to it, add a new product to your line, add a new description of the product, put in some new pictures, you probably should file for additional copyright protection. We've got a helicopter going overhead right now. As I said, Hong Kong's a city that never stops, it always works. What else can you protect with a copyright? Well, you can protect your packaging. Your packaging is often one of your most valuable assets because it will contain some specific colors, shapes, logos, or something like that that indicates the brand of your product or where it comes from. Now, if you're trying to protect a logo, again, you need a trademark for that, but with copyrights you can't protect the general concept of your packaging. With a copyright, you can also protect your owner's manuals. There have been a surprising number of cases where people have perhaps copied a product but not enough to infringe a patent. They've come up with a similar name that's not quite close enough to be able to stop them through trademark infringement, but they've been dumb enough to just copy your owner's manual and just run it through a photocopy machine. So you might want to copyright your owner's manual as well. And finally, any advertising or promotional literature you turn out on your invention, say for a trade show or for some sort of a promotional event, you can copyright that as well. What's the advantage of copywriting something? Well, the first thing is that a copyright is in many cases the least expensive type of intellectual property protection available. The second thing is you can get it back fairly quickly, and it has usually a very high success rate. Most copyright certificates come back within a matter of months, and of course, looking over at utility patents, they take often a number of years even to get examined for the first time. So copyrights in terms of the IP world, they happen with light speed. They're very inexpensive too. This thing about copyrights is that if you have a copyright and someone is infringing your copyright, you can sue them under a theory of statutory damages. And statutory damages allow you to sue for up to $150,000 per copyright infringement where the infringement was done knowingly and willfully. Now, court cases have held that knowingly and willfully basically means that they Control-C, Control-V'd it over from your website to their website. So it's fairly easy to prove because you can sue for up to $150,000 per copyright infringement, and in copyright infringement cases, reasonable attorney's fees and court costs are often included in the award. It's fairly easy to bring these on a contingency fee basis as opposed to most other intellectual property litigation where you're going to be hard-pressed to find a contingency fee lawyer interested in taking on what could be a 5 or 10 year case for a mere contingency.